and this evening we're going over the 2025-2026 legislative update. So this is just a small sample of current laws that passed about last year, October, effective January 2026. So this will be the laws affecting your property owner operation in 2026. So with that said, let's get started. I would say this year was a bit more lenient than previous years. 2025 was a bit burdensome, I would say, for rental housing laws. Some of you, if you remember, they put a cap on security deposits. Owners with more than 4 units were limited to 1 month's worth of rent. Owners of more than 2 buildings were limited to 1 month's worth of rent as well. There are some regulations on no-fault terminations. For example, if you're doing a substantial renovation to get your property back, that required a permit. Furthermore, for owner occupancy or anything, they tightened up on those rules as well. All that became law in 2025. I would say 2026, again, was comparatively more lenient. This focused more on disaster relief, some procedural changes, and also things that I think are a bit redundant or anything, things that you may recognize or you think as a property owner that the state of California tightened up on in 2026. So again, hopefully it's not too burdensome for 2026 for our owners. And with that said, let's get started. AB 628. Now this one I've gotten a lot of questions on. Now this requires the provision of a stove or refrigerator for all tenants. So this applies to single family homes, condos, multifamily properties throughout the entire state of California. Contracts that begin on January 1st, 2026 or after, renewals that begin on January 1st, 2026 or afterwards, you must provide a stove and a fridge in the unit. So that part's not too scary for most people. You know, despite the fact that they now have to have a fridge in the unit or anything, they're saying, hey, if I have a new contract, I'll have a fridge and a stove in there. It's not too much of a burden. The third aspect of it, I think, will catch a lot of people. If you amend any rental agreement, that also triggers a requirement to have a stove and a fridge in the unit. So let's slow down here. If this is a mutual amendment, meaning that we're adding a new tenant to the contract, we're giving the tenant a garage, for example, these are changes that require both parties to sign off on this. So normally you would have an addendum. So for example, maybe you're adding a new tenant, for example, you would say, I'm adding a new tenant, here's the information, and both the landlord and tenant must sign this document. You're amending the contract. Or you might have a unilateral change, such as, I'm increasing my security deposit, I'm making my building a no-pet building, changes that are done just by the owner by serving a notice. Any modification, any change, whether it be mutual or one way, that will trigger the requirement to have a stove and refrigerator in the unit. Now, we had a seminar on this topic or anything, on January 20th here at the association, and surprisingly, there is kind of a loose consensus among attorneys or anything. And what I mean is that, what exactly is the definition of amendments or anything? Meaning, does that include rent increases? Having conversations with various attorneys and also our seminar on January 20th, this excludes rent increases. So all changes that you can think of, I'm making my building a no-pet building, I'm giving my tenants a garage, the entire constellation of changes that you could think of, that will trigger the requirement to have a stove and refrigerator in the unit. The only exception being a rent increase. So a rent increase will not trigger the requirement to have a stove and refrigerator in the unit. Now, a couple of nuances to this. We have a form for this. It's form number 43. 43 is the appliance addendum. Now, on this addendum, you can allow the tenant to have their own fridge. You may have a situation where the tenant says, hey, you know, this is a really great offer, but I have my own refrigerator. That's fine. On form 43, you will document to say, tenant, you are using your fridge, so I'm satisfying this law. And furthermore, you're responsible for your repairs. So your fridge breaks or whatever happens, you're responsible for that if you have your own fridge. Now let's just say the tenant throws away their fridge, or their fridge breaks down and they just can't afford to repair it. So they're now without a fridge. In that case, you will then have to provide them a fridge. So again, if a tenant has their own fridge and they want to use their own fridge, that's fine. But the moment that they lose their own fridge, maybe they give it away, maybe it breaks down and they just can't afford to fix it, then you have to provide them a refrigerator. Question comes up, what type of fridge? Pretty standard fridge or anything. I mean, here's kind of an illustration right here at the bottom or anything. So there's an ice box, there's a refrigerator. You wouldn't want to get one of those tabletop refrigerators or anything, something that's pretty standard for an apartment. And again, this is for a stove and refrigerator. Most apartments already have a stove, so this will largely be, at least in practice, mainly refrigerators. AB 246. Now, last year with the government shutdown, there was a bit of a fear among Social Security recipients as to whether the benefits would be, there will be a cease in their payments, a delay in their payments. This law states that if there is a pause in Social Security payments, whether that be due to government shutdown or whatever the reason is, and the tenant is in the middle of an eviction process, that eviction can be paused up to 6 months. So I'm a Social Security recipient, and God forbid there's maybe a government shutdown and there's a cease in Social Security payments. Well, if I'm in the middle of the eviction process, that eviction can be paused for 6 months or until those benefits resume. So there's a bit of a safety net, if you will, for Social Security recipients. Now, maybe you're not in the middle of an eviction process, and the tenant hasn't paid rent for maybe 4 or 5 months, for example, due to a pause in their payments. If the tenant has a pause in their payments, that rent is still due. When the Social Security payments return to them, when the payments resume, they have 14 days to either pay back that past rent or go into a payment plan with the landlord. So I'm a tenant, for example. My Social Security payments have been paused for whatever reason. I haven't paid you for maybe 4 or 5 months. 14 days after my payments resume, I either have to pay the entire amount back or set up a payment plan, which I see is probably much more common. I'll see that more common with recipients. Now this will expire on January 20th, 2029. So this is only a short-term safety net for Social Security recipients. This first line I didn't mention, and this is already, they're kind of doubling down on fair housing law. You cannot discriminate over the source of income over a for a tenant. So whether the source of income be Social Security payments, disability payments, I'm working a 9 to 5, wherever the money comes from, as long as it's consistent and verifiable, you cannot discriminate against a tenant receiving those funds. So in this case, a person receiving Social Security benefits, whether it be Social Security insurance or disability, you cannot reject them, reject their application, or turn them down solely for having Social Security benefits. Now, there is a real estate investment firm called Greystar, and they're one of the largest investment firms in the country, and they have a portfolio of $76 billion in assets. So again, very large real estate portfolio. Another company, RealPage, this is a property management software company. So back in 2025, the Department of Justice and 10 attorney generals or anything from 10 states filed amended an antitrust lawsuit. They had a lawsuit against RealPage, but they amended that lawsuit to include Greystar. What were they doing? They were engaging in price fixing. Greystar was providing them tenant information, and Greystar would coordinate their payments or anything. They're more or less price fixing. So there was a collusion among all of their asset holders. Now, what this does or anything, if you have price fixing, it's a less competitive market. Rather than you trying to compete and have something that's much more competitive than your other landlords or anything, here, in this case right here, the prices are being fixed. So it's a less competitive market, and usually the prices are much higher. As a result of this lawsuit, RealPage, the restrictions were put on RealPage as to how that information could be used. So certain landlord-tenant information limits were placed on it, and also colluding or anything, colluding for price fixing was also punitive damages or anything were levied against Greystar and RealPage for this price fixing action. And I mention this because California passed their own law, AB 325. California already has an antitrust law called the Cartwright Act. So the Cartwright Act is an antitrust law. It prohibits contracts, combinations, conspiracies, and any sort of unlawful activity that restrains trade in California. So what AB 325 does, it strengthens laws against agreements where competitors are price fixing. So maybe you have multiple property management companies, for example, or maybe a single company managing many properties. They're taking tenant information, using that information, whether they get it from a proprietary source or some software company, for example, and they're engaging in price fixing. And that price fixing can be across their entire portfolio, or they may say, for example, in this part of town, we're going to set the rates at this rate across the board for all of our asset holders and so forth. More or less, it's a less competitive market. So rather than having owners set their rent rates or anything for themselves or anything based on market conditions, they already have preset prices or anything, whereby there's no competition in the market. So as a result of this or anything, AB 325, if any property management company, asset holder, for example, is found to be colluding in price fixing, punitive damages will be levied against that company. Furthermore, even so for example, if I were a large asset holder in California, everyone here in this room were individual property owners, and I took data from maybe a software company and I'm fixing all of your prices, I would be the first target of AB 325. I would pay a pretty stiff fine, and in addition, to the degree that your inclusion with me, maybe you're totally in the dark about this. You don't know that I'm price fixing your properties. I would get most of the blame, but if there's a bit of collusion between me and you would also get a much more smaller fine from this law. So again, it prohibits price fixing, and more or less, it's not just the price fixing, but it's the collusion or anything, though. To what extent are we coming together, whether it be myself, an asset holder, smaller property owners, and even property management software companies giving the information for price fixing in the first place? AB 414 deals with security deposits, and no, this is pretty interesting. Now, as you know, upon a tenant vacating the premises, when the keys are put in your hands, you have 21 days to return the security deposit. That means that when a tenant leaves the property, you have 21 days to have the security deposit information in the mail. And this is namely 5 things. You want to have the security deposit accounting statement, which is your ledger of charges that you're charging the tenant, photographs of your charges, or rather of the damages, a small written sentence describing why you're charging this person, any receipts at 125 or above, and of course any money left over in a check if anything is left over. Now, under AB 414, maybe I don't have all of my numbers right away. I've seen situations where there are many damages, and the landlords only have an estimate. They don't have the final cost. Here, I would still send out my ledger sheet by the 21st day with my estimates, but as soon as I have my final invoices, the final numbers, I have 14 days to give a copy to my former tenant. So again, you're my former tenant, you move out, I'm running around allocating the damages, but I don't have I only have estimates for a few items. I would still send off my ledger by the 21st day, and then finally, when I have my receipts for the final cost, I would send that to you within 14 calendar days.
Is that with the money? I mean, you don't send the money at the 21 days if you're still waiting for invoices?
Good question. That's the drawback. So you would still send the money and everything. So there is a chance or anything that you may either overshoot it, for example, to say, hey, I'm going to give an estimate, and the estimate may be much lower, for example. I get my final invoices, and it's maybe a bit higher. So yeah, there is the fear of doing that everything. So you want to have everything, including the check-in, for example, by the 21st day. It's just the invoices that you want to have, the final invoices, given within 14 calendar days of when you receive them.
You could estimate, basically you could estimate that it was maybe a little bit higher, then you could give them an additional refund if it was less.
Exactly, and that's a good question that you bring up. So you may have a situation where you say, hey, I overcharged you, for example, for something. It was much lower. In this case, I would adjust my statement and refund those funds. And it brings me to a second point. The tenant, if they request proof of, well, why am I being charged for this item, for example, you have to provide receipts to them within 14 calendar days. So maybe there's a carpet repair, for example, and the tenant is contesting that. So the tenant says, well, you know, I want proof of this. You would have 14 days to provide them a copy of that invoice. Also, with security deposits, if I pay my security deposit to you electronically, maybe through Zelle or through a wire transfer, I can agree with you to have it returned to me electronically as well. So I move in maybe a year back, I pay my security deposit via Zelle, for example, electronically. Before leaving, I can agree with you to say, hey, I want to receive my money, my security deposit refund, also electronically.
Can I have a question about, I always prefer my deposit, everything is digital except the deposit, because I want to know what the bank account is. That's important to me to have that information in case something happens. Knock on wood, I've never had a problem, but I just think that it's important that I have the actual check from them, just from the security deposit. Is that allowed, that I can request that?
Yes, so actually you would probably have their checking account hopefully on the rental application. You would gather that everything and then maybe kind of cross-check that when you get the check. So yeah, that's definitely a good tactic. Also, the itemized statements can be returned via email. So everything that I mentioned, the security deposit accounting statement, the photographs, the invoices, that could also be emailed back to the tenant. So there could be a situation whereby I am going to send back your security deposit funds electronically, maybe via Zelle, for example. I'm also going to return the documents, the statements, the photographs, etc., the invoices via email. So we're going to have a form for this whereby the tenant can say, hey, I would like to receive my funds electronically. Or furthermore, I would like to receive my documentation via email. So we're going to have a form, I would say, before Valentine's Day for this process. Number 3 is a very good one, you know. Tenants can mutually agree to divide up the security deposit. So normally if you had 3 tenants, for example, and you're returning the security deposit, you would have a single check with all names on the deposit. Under AB 414, tenants can agree to divide up the deposit amongst themselves, but this has to be an entire household agreement. So you can't have maybe 2 out of 3 people colluding to say, hey, let's divide it up this way. The entire household has to agree to say, hey, it's 3 of us, let's each get 1/3, for example, of the security deposit. And of course, if no one could come to an agreement, then you simply return a single check with all the names on there. So again, they're trying to streamline the security deposit process or anything where it can be returned electronically, the documentation can be sent via email, and if you have multiple household members, they can come together and agree to divide the deposit up. And here's a bit of a graphic or anything here. So the old way, which is still current, it's still effective, I can either return everything, the documentation via first-class mail, I can return a single check to the entire household, or here in 2026, I can return your security deposit electronically, maybe Zelle or a wire transfer. I can email the documentation. Again, this has to be agreed upon beforehand between you and the tenants. I can send the invoice, the photographs, the security deposit accounting statement via email, and of course, the deposit can be divided up between household members.
I'm sorry, one more question about this. So let's say you, do, in this new document they're going to, is it required, let's say they, at the last minute, they sign this document, says, okay for return multiple ways, I mean digital ways, but what if you, are you allowed still to do the physical, or do you have, is the contract that you sign on that form only required that you do electronic? Or can that be changed?
So the electronic thing, it's only if the tenant pays initially electronically. So if I pay my security deposit electronically initially coming in, I have the right to demand it be sent back to me electronically.
Okay.
As far as the email documentation, that is a tenant request. So if the tenant says nothing, then you know the old way. But if the tenant says, "Hey, I would prefer to receive this via email," then you have to give in to them and, you know, oblige them and send it via email. SB 9, you know, I would say since the year I would say 2020, there have been more laws relaxing ADU and JADU construction, largely due to a lack of housing in California, and they want to encourage the construction of more ADUs. So what this law allows for, it allows for the building of more ADUs on areas zoned for single-family homes. So you might have an area, for example, that's zoned for a single-family home, allowing for maybe one ADU. Now with SB 9, you can have multiple ADUs or anything, or building an ADU on a smaller area previously zoned for single-family homes. Some cities require an off-street parking requirements when you're building an ADU. That's also been eliminated. So the provision of off-street parking is no longer a burden for building an ADU or a JADU. Again, relaxing the requirements or anything and encouraging the building of more ADUs and JADUs. Also, setback requirements. This is the distance between the property line and the structure or anything, though. That's also been relaxed or anything, though. So again, really 1 and 3 or anything, we have greater density here. I'm able to build more ADUs on an area zoned for a single family home, so I can cram more housing in a single area. And furthermore, the distance between the property line and the structure can now be reduced or anything. You know, again, greater density, essentially squeezing more properties or anything on square footage on your lot. And also, I think the next graphic or anything explains the second part a bit better or anything. Now, SB 9 or anything, though, allows cities to create ordinances to set this in motion. So let's say this is the city of Lakewood, for example. The city of Lakewood writes an ADU ordinance. After the ordinance is submitted, or drafted, they have 60 days to submit it to the state of California. The state of California will review it, ensuring that it complies with SB 9. If it does not comply with SB 9, they would return it to the city, and the city has 30 days to either prove why their original draft is valid, or make the changes within 30 days' time. So it's a much quicker process. Again, upon adoption, I submit it within 60 days to the state of California. If the state of California has any contention with it, or rejects it rather, it shoots it back to the city of Lakewood, for example. City of Lakewood has 30 days, or any other city, 30 days to either modify their ADU ordinance or anything, or prove why the ordinance or anything is valid. And if they fail to get it back to the state of California by this deadline for approval, then the ordinance is void. It's off the table. So it's a much tighter deadline, and state standards take over. So rather than the city drafting an ordinance for ADU and kind of sitting on everything, there's a bit more urgency to submit it to the state of California. California gets it back to them. If any changes are needed, changes must be made within 30 days' time. And if they're not committing to that deadline, the ordinance is now null and void. They're back to square one. And the state of California, their guidelines take over in terms of ADU construction. So it kind of puts, again, a bit of urgency on the city to get the ball rolling on ADU ordinances. Oh, a junior ADU, so just a smaller ADU, a junior ADU. So just a smaller ADU.
Okay, real quick on this, I'm trying to understand this. Local, okay, so this is me. I want to build an ADU in my back unit, okay. I submit to the,
Oh, no, so
to
this is-
Lakewood? No.
So this is dealing just with the city. So this is, so not the individual building, but the city. So I'm a representative for the city of Lakewood or Long Beach, for example. Me and my committee, we draft an ordinance, or anything, to more or less put these guidelines into practice. So I'm drafting a new ordinance. When I draft that ordinance, the moment that it's drafted, I have to get it to the state of California within 60 days' time. The state of California says, Oliver, does your ADU ordinance, does it jibe with SB 9? And if not, or anything, if we see some areas that we don't agree with in accordance to SB 9, we're going to give it back to the city. The city has 30 days to either tell California, hey, this is correct or anything, to argue with them, or make the changes. Submit it within 30 days' time. If you don't get it back by that deadline, then that ordinance becomes void, and the state of California steps in with their own guidelines. So again, if the city drafts an ordinance, they have a much tighter deadline to get it to the state of California. California amends it or anything if necessary, or rather gets it back to them if necessary. And beyond that or anything, if it's not met by that timeline, it's voided, and the state of California takes over. Hmm? Exactly. SB 610. So unfortunately, we've had a couple of disasters or anything last year and even in prior years in California, and this deals with the cleanup and kind of getting people back in their homes after a disaster. So if there is a disaster, either a locally declared or state declared disaster, whether it be a flood, fire, etc., the owner must draft what's called a resident replacement or relocation plan. So what does this look like? So I'm an owner of a property, and I experience either a flood or a fire, for example. It's a state of emergency. I must first clean up the mold, the ash, the smoke damage, anything that's obstructing the immediate area. And these instructions will either come from the state of California or your insurance company. So there's a cleanup responsibility on the part of the owner following a natural disaster. Furthermore, if my tenant has to leave the premises, maybe my building was damaged, for example, the tenant leaves the property, or rather they're forced to leave the property, rent payments are paused. So the tenant leaves the premises, they're forced to vacate. I'm fixing up my immediate area, I'm fixing up my property, the contract is still active. Rent payments are paused. When the unit is refurbished and set up again, the tenants can return and resume tenancy at the same rent rate. So normally, for example, if your property were damaged, and you're doing work on the property, and the work takes more than 30 days, normally that would end the contract. I'm doing substantial renovation, for example. I'm doing work lasting 30 plus days. This is different. This is damage due to a natural disaster. So it doesn't matter if the repair work takes more than 30 days or anything. I, a tenant, maybe staying in a hotel, for example. Meanwhile, you're cleaning up the immediate area, the mold, the ash, the debris, etc. Maybe you're fixing up the property due to damage from that natural disaster. And whether that work takes you 4, 5, or even 6 months, I have the right to return to my previous home or anything, paying the same rent rate and picking up where I left off. In the case of a mobile home park, I would only be responsible for the land, the mobile home lot, not the mobile home, vehicle itself or anything. Of course, in the case of an actual residence or anything, no, I would be responsible for the residence. So this adds a bit of a safety net, if you will, for those who have been affected by a natural disaster. They have to temporarily vacate their homes, and it gives them the ability to return back to their homes after the cleanup work has been done.
I know this is going to sound strange. We have Paradise property that had the fire. Our, knock on wood, thank God, our place did not burn. It was a fourplex. But the tenants all moved out. We didn't have water for 4 months. And everybody moved out. I gave everybody back their deposit. but nobody came back or asked to come back, and like 8 months later, I was able to rent 1 unit, and I did. So can they come back now and say, I mean, this was 8 years ago.
Oh, no, so,
Yeah.
so this went into effect January 1st, 2026.
Oh, okay.
So back then, it wasn't luckily in effect at that time or anything. But yeah, but following, say, the Eaton fire, the Palatine fire, for example, I think that's when that came into effect or anything. That's when that became an urgent matter. So again, yeah, so, but, and you bring up a good point, for example, maybe due to a fire, flood, or whatever, for example, I leave the premises for 4 or 5 months. Most people would probably find a new home by that point in time, I think, but just in case, if I don't have any new lodgings, I can return to my former address. AB 1414, so some landlords provide internet service built into their contract. They may say, for example, I'm providing internet service with AT&T, you're going to be charged a fee of $100 a month, for example. Here, the tenant is not required to participate in that service. So I may move into your building, for example, you're providing internet service. I may say, you know what, I don't want that service. So you cannot charge me, or rather force on me, this additional service that I would probably pay for. Furthermore, if you are charging me for that service and I don't want it, I can take it out of the rent. Now again, this does not apply to other utilities. Like for example, if this were like the light bill or the gas bill, that's, you know, you can pass it on to them, of course. This is only for internet service.
Okay, this is another odd question. Would this apply to assisted living? I have a dear friend that's living in assisted living, and she has to pay for the cable, and she doesn't want to. So would that apply?
No, so this would be, so it's effective January, so this would be for, hey, I'm an
Landlord
incoming tenant
tenants.
or anything, no, as of January 1st, 2026.
Okay, but assisted living homes wouldn't, doesn't apply to.
If I were moving into an assisted living unit, for example, January 1st, 2026 or afterwards, or anything, you know, yes, it would apply. I can say, you know what, I'm moving into an assisted living community, for example, and I don't want internet service. Maybe I have a different service, for example, so yeah. So this is pretty straightforward. Again, you cannot force a tenant to pay for internet service if they don't want to. Even if it's part of the contract, they can opt out. And furthermore, if you are charging them, they can take what you're charging them, or anything, you know, out of the rent that they're paying. And of course, there's no retaliation. You can't threaten them with eviction or termination if they don't want to join this program. AB 747 or anything. So this is really for the courts or anything. So as you know, if you're filing an eviction, a plaintiff is served with what's called a summons and complaint. Now with the passing of AB 747, county clerks must provide a local register of process servers or anything. So rather than you just kind of randomly looking for a process server, here you're going to have a list of process servers given by the county clerk. Now these process servers or anything that are listed by the county clerk, they must make 3 attempts to serve the plaintiff, three attempts at least or anything. And when they serve the tenants on the proof of service, they must include photo of the person being served, the date when the person was served, the time, and also the GPS location of where the person was served. So a lot of information as to when a person is served for the eviction process. If they cannot provide this information, they have to provide a written description of why this information couldn't be provided and what took place. So again, I'm a process server. I'm listed on the local register by the county clerk. I'm going to serve your plaintiff for an eviction filing. I make 3 attempts at least to serve this person or anything before using an alternative method. And when I serve this person, my proof of service must include, again, at least photo with the date, time, and GPS location, or a written description of how this person was served. So again, a bit of transparency as to how plaintiffs are served. ensuring that a person can't say, hey, I wasn't served or I wasn't served properly.
So you have to pay something to do with that.
Well, actually, normally you probably pay an attorney. The attorney would have a process server that they're using, and that process server would be listed likely on this register by the county clerk.
Oh, so you can't serve it yourself, no?
No, not for an eviction. If this is anything else, if this is a rent increase or a termination notice, yes, you can. But now you're going to court and you're serving a summons and complaint, you're filing an eviction, that you cannot do yourself. A lawyer, and they would have a process server do it for them, yes. AB 1529 or anything. This one, I really like this one. So, as you know, California in 2020 passed the Tenant Protection Act of 2019, or basically statewide rent control. Properties of 2 or more units are under statewide rent control. So you have a duplex, a triplex, and above. You have annual rent caps, and after 12 months, tenants have just cause protection. So you're under statewide rent control. Single-family homes, condos, and townhouses are exempt from statewide rent control. But you must have the proper notice in your contract, and many people neglect that. So if I have a single-family home, a condo, or a townhouse, I would be exempt from statewide rent control, but I must have an exemption notice in my contract. What this law says is that that notice can now be included in the actual contract itself. So the Apartment Association has that notice as a separate addendum. Now this will be added to our contracts. Now it will be included in the language in the contract. It ensures that you don't mistakenly not include it, basically. And I've spoken to many individuals that say, hey, Oliver, I have a single family home or a condo. I believe that I'm exempt. And then I'll go a bit further. I'll say, hey, do you have the exemption notice in your contract? Well, what is that? So you must have an exemption notice, for example, to get the exemption. This law says that language can now be in the contract.
We're going to get a new one?
Actually, so it'll be our existing contract, it'll be added to our existing contract, so you can't miss it, basically, everything. This may or may not apply to you. So if this is for assisted affordable housing, if there is a notice of opportunity to purchase, so maybe a nonprofit or a public housing authority wants to purchase affordable housing, well, that notice of opportunity to purchase must be given within 12 months of a notice of change. So for example, maybe I own an affordable housing unit, for example, and my subsidy is going to expire, I'm going to sell the property, or my rent restriction will end, for example. I must post a notice of opportunity to purchase possibly by a nonprofit entity or a public housing authority. So they're not blindsided as to the sale of this property. And why is this important? So that these properties will not lose their rent restriction protection. Also, the rent rates for these properties will now be set by the California Tax Credit Allocation Committee. So previously, for example, there would be 2 measures or anything as to how much of a rent reduction assisted affordable housing would receive. Now this would all be determined by a single entity, the California Tax Credit Allocation Committee, having a single committee determine how much of a rent reduction affordable housing units should receive. Now, this first part deals more with policy, and here's what I mean. So, SB 655 states that going forward, any sort of grants, ordinances that are written, programs that are created for housing must include a provision to maintain a safe maximum indoor temperature. So maybe a city is drafting an ordinance, for example. Maybe the County of Los Angeles is putting together a new zoning policy. Whatever sort of policy is being enacted that involves housing, for example, must include a provision whereby, hey, you as the owner, if you're going to build property, for example, you must maintain a safe maximum indoor temperature. So this will not become more or less a a requirement for, say, giving grants, for example, giving tax credits, revising housing policies, for example. All of these things will now consider maintaining a safe indoor temperature. Now, what is already passed is here in the city, rather in unincorporated Los Angeles County, they've already passed this ordinance. So I would say about mid last year, unincorporated Los Angeles County passed the Cool and Healthy Homes Ordinance. Basically, they're requiring a maximum indoor temperature of 82 degrees Fahrenheit. So if you're a property owner with a property in unincorporated Los Angeles County, and really it's effective, it's effective in 2027, you must, whether that be your tenant gets an air conditioning unit, for example, you're putting in windows, a ceiling fan, whatever you're doing or anything, you have to at least maintain a single room a maximum of 82 degrees Fahrenheit, and I believe by 2030, all rooms must maintain a maximum temperature of 82 degrees. Yeah, here's the thing. I'm glad you said that or anything. So let's just say, for example, now also another thing, I'll get to that. This is only in unincorporated Los Angeles County, but the ordinance also says other cities can adopt this should they choose to. So let's just say Long Beach says, hey, we're going to adopt this ordinance for ourselves, for example. You must maintain, now, and let's fast forward, it's the year 2028. We have a severe heat wave, and tenants are complaining, saying, hey, I'm complaining, it's very hot, my phone, my thermometer in the unit states that we're above 82 degrees Fahrenheit. I'm making complaints to you over and over again. You're not responding. I call the city of Long Beach, the PRIP program, the housing program for the city of Long Beach. They may apply this. They may say, hey, you're now required to maintain a maximum indoor temperature. We're in the middle of a heat wave. I've got a complaint from your tenant. Now you're on our radar, and so the onus is upon you to do something. This ordinance doesn't say that you must put in an air conditioner, but if you're in that situation whereby, hey, we're in the middle of a heat wave, I'm getting complaints from my tenant, I may have to take the onus and put an AC unit in my building.
Yeah, just one room, you said.
What?
It said one room?
Well, here's the thing. So by 2027, one room. By 2030, all rooms. Oh. So again, I mean, so getting back to your question, yeah, you would only know that in the event of a heat wave, you're getting complaints, and maybe I reach out to the city, for example.
If you have air conditioning, it's okay.
You have air conditioning, and it's able to maintain, of course, a maximum temperature of 82 degrees Fahrenheit. So that's your target. Which is pretty, a pretty reasonable temperature for the most part. But again, so again, although you're not forced to put in a ceiling fan or an air conditioning unit, if we're in the middle of a heat wave and it's pretty apparent that, yeah, we're above 82 degrees Fahrenheit, and furthermore, there are complaints coming from my tenant to the city, yeah, it's a bit of pressure on you to do something about it.
But listen, suppose you have air conditioner and fan, and the tenant complain because they don't want to pay the bill, and they still complain. You can't do nothing.
Well, here, that's different. No, if it is there and it's working or anything, and they don't use it, then that's on them or anything. Because the means to maintain the temperature is there. If they don't want to, and furthermore, the contracts require the activation of electricity. So I'm going to have active electricity. If I don't want to flip that switch and use an AC unit, that's my choice.
Oh, okay.
This is also another one that's related to the recent disasters, the Eaton fire and the Palisade fire. So if I am a mortgage holder and due to a declared wildfire emergency, and of course, these are only for properties of 4 or fewer units, I can get a forbearance on my mortgage payment up to 90 days' time. So I'm a mortgage holder, I have 4 or fewer units, I've been affected by a wildfire, I can get a forbearance on my payments up to 90 days' time. So that means that I can avoid an eviction, a foreclosure judgment sale, etc. And I can get an extension for an additional 90 days at request. Now this forbearance can go up to 12 months' time. So again, I'm a homeowner, I have 4 or fewer units. I've been affected by a wildfire, for example. I'm working with my insurance company. Meanwhile, I'm concerned about paying my mortgage. Again, I can get a forbearance for up to 90 days, get an extension, up to a maximum of 12 months' time. Now, the thing about this only applies to statewide mortgages. This does not apply to federal mortgages. So if I'm getting a federal mortgage, for example, their rules are still in effect.
FHAs, you mean?
Exactly. So it's kind of a curveball. At the state level, I would be covered, but maybe I have a federal loan, for example. Those rules are still in effect, which may result in an eviction or a foreclosure, for example. So, whereas on one level, I may have a safety net, on another level, I may be between a rock and a hard place. So again, just to summarize this is more or less a forbearance program for mortgage holders that have been affected by wildfires. They can get a forbearance up to 12 months' time. This is for smaller property owners of 4 or fewer units. Again, this helps me to avoid late fees, interest, foreclosure judgments, evictions, or sale. But again, this does not cover larger units, more than 4 units or anything, or federal backed loans. So again, there are some limitations, there are limitations in AB 238. Okay, again, and notice a bit of a theme in these laws or anything, so this is all responding to natural disasters or anything, unfortunately, many of which we experienced last year and the year before. Maybe there's a natural disaster declared at the local or state level. Tenants are now staying in a hotel. Now, as you know, a short-term tenancy is under 30 days. A short-term tenancy is under 30 days. Now, under normal circumstances, a hotel owner can evict a person should they stay in a unit, in a hotel room, more than 30 days. Under this law, if my extended stay is due to a natural disaster, maybe there's a fire, for example, I'm staying in a hotel and I stay beyond 30 days, I'm not seen as a tenant now, and I cannot be evicted due to me staying beyond 30 days. So it allows those affected by a natural disaster to stay in a hotel room longer than 30 days. They're not regarded as a tenant, and they cannot be evicted for staying beyond that 30-day time. Now, of course, if I am not paying for lodging, I'm causing a nuisance issue, disrupted, yeah, for those reasons, of course, an eviction can be filed. And now this does not apply. Now, of course, if this is, and it's kind of a given, if this is a non-disaster related issue, then this does not apply. So if I'm just staying in a hotel just for whatever reason, I stay beyond 30 days time, I can be evicted for staying beyond that point in time. So again, just to recap everything, this is, again, a safety net for those affected by a natural disaster. It allows them to stay, and kind of connecting it to our earlier bill, I can stay in a hotel beyond 30 days time while you're fixing up your unit that was damaged, and I can return to my same unit, my home, paying the same rent rate. So a pretty large safety net for those affected by a natural disaster. This deals with summary proceedings for an eviction case. So if I'm filing an eviction under, this is AB 1384, I'm filing an eviction, and if I want to have a hearing where I want to strike something from the record or anything during the eviction process, that has to be done mutually. So both parties can agree in writing to either file for a hearing or get an extension on their case, or a motion to strike to remove something from the complaint. So rather than an attorney, for example, or a party extending the case indefinitely, this requires a bit of mutual agreement between both parties for either a hearing or for a motion to strike. So this keeps the eviction process on a much tighter schedule. So rather than a person, say, having a hearing that's maybe weeks from now, for example, and now I'm going to file a motion to strike, and there's a lot of delay tactics, which extends the eviction process. Much of this must now be done either by both parties, either in writing or orally. And for a commercial case or anything, this can only be done 10 court days after the original hearing. So this puts a much tighter deadline, or rather timeline for eviction filings, particularly on hearings on demurs. So for a request for the case to be dismissed based on insufficient evidence, or a flimsy legal precedence, or a motion to strike, removing certain parts from a complaint. These motions or anything must be done through mutual agreement.
What's the demur?
Demur thing says, so hey, I believe that there is an aspect of this case that has a very flimsy legal aspect to it. It doesn't stand on strong legal grounds. So I want that to be, I want to dismiss the case based on that weak leg. Okay, so this is a pretty good one. So this is for short-term residences. So short-term platforms like Airbnb and Vrbo, for example, they must now list their properties or anything with the city where they're located. Now, much of this is already in play. For example, if you have a short-term tenancy, a short-term residence in the city of Long Beach, you must register with the city, you must pay an annual fee, and so forth. So if you have a short-term tenancy, so you have an Airbnb, a Vrbo, so it's not a regular landlord-tenant relationship, rather a short-term tenancy like Airbnb, for example, those properties must now report their physical address, any details about the property, for example. So this is a front house, here's the address of each unit. Any certification that I receive from the city must be posted on the property, and this must be submitted within a reasonable timeline. So using the city of Lakewood, for example, I have an Airbnb in the city of Lakewood. I would report to the city or anything the physical address of that property with the zip code, any sort of additional information, whether it had a garage, a back house, any sort of amenities, for example. And the city would likely give me either a permit number or some sort of placard, for example, some sort of posting that I must have on the property while I'm running my business. So this allows the city to more or less levy taxes or anything for those services, and it makes it a bit easier for them to identify these properties. Now, of course, the people staying there, the guests or anything, though, that information is not required. So you wouldn't give the names, contact details for those staying in an Airbnb, for example, but just information on the property. Now again, notice I put this in bold. Cities and counties may adopt a local ordinance. So right now, most cities already have some sort of short-term tenancy guideline. Like the city of Long Beach, for example. I think it's like they allow 1,000 short-term tenancies in the city of Long Beach. There's a small annual fee. You register online. They can now go a step further and apply this or anything in their city. So this more or less gives the green light, if you will, for cities to adopt this measure and tighten up their already existing short-term policies.
It's like starting a business. I mean, when you do the Airbnb, right, and then you're letting the city know that you are running a business and you're renting your house out 5 or 6 days a month, and you need to pay some kind of a tax on it.
Exactly.
Yeah, right.
A fee and a tax, exactly, yeah.
15% of what you make.
15%? Yeah. 15%.
So, we hit the end of this talk, so any questions at this point in time, I think? You go ahead.
Yes, we have a couple of people online. So Ms. Jennifer Pilapil is asking if there are damages done to the unit when they are still living there and you repair, can you include the old receipts and take out of their security deposit? Example, the plumbing repairs were there where their son put their toy in the toilet and clogged the toilet. Number 2, repainting their walls for maintenance when we renovated their bathroom. Receipts may not be available since they have lived there for over 10 years.
Okay, so just to understand the question, so tenant has lived there for 10 plus years, damages occurred during the tenancy, and they want to charge him later on when a tenant eventually moves out. So if I understand that
Yeah,
correctly.
if the damages were done to the unit while they were still living there and you repair it, can you include the old receipts and take it out of their security deposit?
Here's the thing though, normally you would address that right then and there because it's very difficult to say, hey, 5 years ago you put something down the toilet, for example, and here's an invoice. I didn't charge you then, but now theoretically you can do that. You can say, hey, here's a receipt for this plumbing bill, for example. I'm not going to charge you now, but I'll charge you later on whenever you eventually move out. That can be done, but it's better to charge them right then and there when it takes place.
She said they refused to pay then and there.
Then that can, at worst, either if not a payment plan, that can lead to an eviction at worst. So you would say, hey, either small claims if I don't want to file an eviction, or I can maybe give you a payment plan, for example. But if nothing can be worked out, then at worst that would lead to an eviction.
Alrighty, and then Ms. Ramona is asking, do all properties require AC units in 2027 or new buildings? All of LA County?
Okay. So right now, unincorporated Los Angeles County, that's only unincorporated Los Angeles County, this is already in play right now. It's really going to be, I guess, enforced in 2027. So now it's kind of the preparation period. They're saying, hey, this is coming down the pipeline in 2027. By 2027, you must maintain at least one room at 82 degrees Fahrenheit. And by 2030, all existing rooms in your unit. Now, we're not mandating that you get an AC unit, but do whatever is necessary. So again, this is only for unincorporated Los Angeles County. Furthermore, the ordinance allows other cities to adopt a similar ordinance. So maybe Lakewood, Long Beach, etc. may adopt a similar rule. Again, by 2027, a single room at 82 degrees Fahrenheit. By 2030, all rooms at 82 degrees Fahrenheit. Must I put in an AC unit? No, nothing in the ordinance says that. But if you find yourself, in the example that I gave, here there's a heat wave, and it's pretty clear that it's above 82 degrees Fahrenheit, it puts the legal onus on you to do something to say, hey, you know what? I'm above that threshold. We're in the middle of a heat wave. I'm getting complaints from my tenants. If they don't do it, then it puts it on me to, yes, an AC unit or a ceiling fan or put something in to maintain that maximum temperature. So although I'm not forced to, the temperature may, in one way or another, force me to do it. So.
Thank you.
Well, I had a question, going back to considering I have a property that someone's lived in for 16 years, it's a home, and I supplied I've always put refrigerators and stoves in their units, but the refrigerator went out, and they never said anything to me, and they put their own in there. So what obligation do I have now? Do I need to go back to them and say, now I can put another one in, or what? I don't know, that's...
Okay, so you provided a refrigerator originally.
Right.
It broke down, they
Threw it out,
threw
yeah.
it out, everything. They
yeah.
put their own in everything.
Put their own in.
I would say, okay, my immediate concern would be, the payment for the refrigerator thing minus depreciation, which would probably be a very minimal amount. Now, initially, this is a tenancy existing before January 1st, 2026. So right now, there's no obligation to put a fridge in. But if I amend their contract later on and say, hey, you know what, maybe I want to make this a no-pet building or any sort of minimal or major change, now I have to offer them a fridge. So at this point in time, no, there's no obligation. But the moment I make a change, then that obligation will kick in. No, yeah, so, if you have a security deposit,
Not security, I'm sorry, the social security.
okay, no, okay, so, no, this means like, the amount you can, critique, but not the source of income. So if they have so, hey, there are two applicants, and his social security is enough to cover the payments. You cannot turn them down for the source of the money coming from social security.
But if he doesn't have enough.
But if he can't afford it, then yes.
Yeah,
The dollar amount, yes, but not the source of the income, yes. And the questions could be about, what we discussed, or kind of any general question beyond,
Just to refresh my memory, when you have two tenants moving in, you have two new tenants moving in, and together, they reach your income requirement. That is okay, right?
Yes, okay, so a couple of things. So you want to have either a joint or an individual policy. And that trips a lot of people up. A person may say, hey, you're a married couple, so I'll look at you as a combination. Versus maybe boyfriend and girlfriend, you must each individually meet my criteria.
Exactly.
You can't switch it up like that. You have to be consistent. Either, hey, I'm looking at everyone as an individual, married couple or not, or as a group. So you pick one policy and you go with that.
I was just interested again about this real estate investment firm. I understood what you said and everything, but aren't they going to get some laws that they're going to stop these people from buying homes and making them rental properties instead of people can't buy homes?
I'll be honest, I really have not seen a slowdown on it. So for example, let's use the apartment association. I've spoken to a number of members whereby, hey, I'm getting out of the industry. I've done this for maybe 30 plus years, for example. And oftentimes, it's usually a corporate entity buying up those properties. I know BlackRock, for example, they've, in recent years, they've really purchased mostly single-family homes, but also a number of luxury apartments. So I have not yet seen a slowdown in that, honestly. So.
Thank you for your help.
Any last questions, anybody? All righty. Well, seeing none, thank you so much for joining us, everybody online, and thank you everyone for coming in person.
All right,
Much
thank you, everyone.
appreciated.
Thank you.
Great job, Oliver. Thank you so much.